السلام عليكم ورحمة الله وبركاته. بسم الله الرحمن الرحيم. الحمد لله رب العالمين. اللهم صل وسلم وبارك على سيدنا محمد وعلى آله وصحبه ومن اهتدى بهديه وانتهج نهجه واستنى بسنته إلى يوم الدين وبعد. So alhamdulillah, we praise Allah subhanahu wa ta'ala for the blessings of continued life and continued ability to learn and to study and to practice this great deen of ours. And we have been reading in the subject of jurisprudence of the Maliki school, Maliki Fiqh, based upon the text of Sheikh Abdulaziz Hamid al-Sheikh Mubarak, which is based upon the text of Ahmed al-Dardir, rahimahumullah, Tadrib Al-Salik ila Qira'at Aqrab al-Masalik fi Madhab Imam Malik. So this is like an abridgment of the Aqrab al-Masalik of Imam al-Dardir, which in turn is an abridgment of Mukhtasar Khalil of Imam Khalil ibn Ishaq al-Jundi, which is considered to be the main resource, the mu'tamad, or the relied upon book for fatwa in the Maliki school of law, in the Maliki jurisprudence. So alhamdulillah, thus far we have completed what's traditionally referred to as Rubu' al-Ibadat, or the quarter dealing with acts of worship. So they traditionally think of the jurisprudence as being divided into four categories or four parts. The first being al-ibadat, acts of worship. The second dealing with ahwal al-shakhsiyya, or personal family law, that includes marriage and divorce and all those things that are connected with it, hadana, child custody, and so forth. And then we have rubu' al-mu'amalat, which is dealing with al-mu'amalat al-maliyah, our commercial law or transactional law. And that includes buying and selling and all those things that are connected to it. And then finally, Ruba al-Aqdiyah, dealing with court law, so that which would necessarily involve a judge, which would include criminal law and hudud and criminal punishments and so forth. So this quarter that we're beginning now begins with Kitab al-Nikah, or the chapter dealing with marriage contract, as he entitles it, Kitab al-Nikah, وَمَا يَتَعَلَّقُ بِهِ. So the chapter dealing with marriage and everything that is connected to it. So the word nikah, nakaha, sometimes we also see the word zawaj, and that comes from zawj, so the pairing of two people. Nikah sometimes is used to specifically refer to the marriage contract, and sometimes it's used to refer to the intimate relationship between husband and wife, depending upon the context. So in this particular context, it could mean both, the marriage contract itself and then what follows, which is the marital relationship. So he begins by saying, rahimahullah, وَنَفَعْنَا بِالْعُلُومِ فِي الدَّارِينِ آمِينَ وَرَضِيَ عَنَّا وَعَنْكُمْ النِّكَاحُ مَنْدُوبٌ لِمَنْ رَجَى نَسْلًا أو كان له أرب ولم يخش الزنا وإلا وجب. So he begins by talking about what is the ruling, what is the legality of marriage to begin with. Is it something that is obligatory, or is it something that is mandatory? Is it something that is recommended, or is it merely permissible? Can it be haram? Can it be disliked? And here the author kind of mentions one or two of the categories, but you can think of marriage as they say, يَعْتَرِيهِ الْأَحْكَامِ الْخَمْسِ, that the five rulings will apply. In other words, it could be obligatory for some people, it could be disliked for some people, it could be merely permissible for some people, it can be recommended for some people, and it can be haram or forbidden for some people. So depending upon one situation, and the situation will be their ability to be married, in other words, to fulfill the obligations of marriage. That's going to be a consideration. So if one is not able to fulfill the obligations of marriage, then this will be a consideration, perhaps that will be disliked or even haram for this person. If they didn't talk about this in the traditional books, but in today's world we can certainly talk about people who have certain perhaps mental conditions, mental illness, so forth, such as that if they were to marry someone, they could cause great harm to their marriage partner. Then we might say that in their particular case, while they're in this condition, it's not allowed for them to get married. It would be haram in this particular case. Here the author says, النكاح مندوب لمن رجا نسلا. So it's recommended generally. So the general kind of, let's say, default state of marriage is that it's recommended. So neither obligatory nor is it forbidden, but it is something obviously under normal circumstances or under conventional, typical circumstances, it's recommended. He says, لمن رجا نسلا, for those who are hopeful or interested in having children. It would be recommended for such people. أو كان له أرب ولم يخشى الزنا, or someone who feels that they should marry, they feel compelled to marry, and they want to, they have an arab. Arab means that they have sexual inclination to the opposite sex, right? And in our understanding, intimate sexual relationship can only be between husband and wife. There is no other, in today's world anyway, there is no other. We don't have, people in bondage anymore. So all that fiqh that used to be talked about doesn't apply here. So it has to be a relationship between husband and wife, and has to be a valid marriage contract, and we'll see all of the conditions for this. So someone who has an arab means a need. In other words, they have a strong inclination obviously to the opposite sex. وَلَمْ يَخْشَ الزِّنَا, and they're not fearful of falling into fornication, then it is mandub, it's recommended. وَإِلَّا wajab. In other words, if you do feel you're going to fall into zina, you're going to fall into sin, into fornication, then in this context it might be obligatory to get married. Because if you do not get married, then you fall into the haram. And so avoiding the haram takes precedence. So in this case, then someone should seek to get married. When is it going to be haram for somebody? If they can't fulfill the conditions, as we said. They don't have the nafaqah. Husband, for example, the man doesn't have enough to actually support a wife, and they resort to illicit means to go about doing that, then in this case it would be haram for them to marry in that scenario. And when could it be makruh? It could be disliked for someone who maybe has the ability to get married, financially speaking, but they don't really have an inclination or a desire to have children or to be married or to fulfill let's say, the intimate relationship rights of the spouse. Then in this case it might be disliked. So one of the obviously the goals of marriage is that there has to be a partnership, and there has to be compatibility, and there has to be kind of a mutual tolerance and compassion and mercy and understanding between the husband and the wife. So one thing before we go any further that I want to point out is that when we talk about books of fiqh, when we're talking about marriage, they're not exactly telling you how to go about doing it. They're not really talking about the adab and the etiquettes and the beyond the do's and don'ts. It's not talking about how to actually conduct a relationship. Here it's specifically concerned with legality, right? Is this a valid marriage contract or not? Does this nullify the marriage contract? Who has the right to be the wali, or who has the right to be the guardian? Who can perform the marriage, right? Who can, on behalf of the wife or on behalf of the husband, and so forth. But not really looking at kind of, okay, now how do I conduct my relationship? This would be studied in something else. This would be akhlaq. This would be character and building of character and understanding the rights of others and so forth, which is not going to be entirely covered by just kind of the legal framework by which marriage exists. So that's something that's important. Sometimes the fuqaha will when they are pressed and the case is brought before them and they need to determine kind of the legality of something, like how should household chores be divided, or who's going to be responsible for what, and there's a dispute or there's a lack of agreement between husband and wife, then in this case some of the fuqaha might mention that this responsibility falls on this person or falls on that person. But otherwise, the inner workings of the relationship and what goes on in the home and who does what and so forth, for the most part, that's just up to mutual agreement. The only thing that's really stipulated is that the husband, the man, is the one who is responsible for the upkeep of the home and of the wife and of the children. In other words, from the nafaqah or from earning a living to support a family, and that the wife is not asked to do that. She's not. It's not mandatory for her to do that. If she contributes to something of the household income, that's up to her. But under no way should she be coerced in doing so, because it's not her responsibility. If she chooses to do so, then that's something of her own volition. Otherwise, how things are divided, and who cleans the sink tonight, and who takes out the garbage, and who mows the lawn, and all those things are, the Sharia. It's all in the realm of permissibility, and perhaps a little bit of culture comes into that as well, of how people want to go about doing it. طيب وأركانه خمسة. So here the arkan or rukun, singular, means the essentials. So without these things, you don't have marriage. That's what that means. وأركانه خمسة. So its pillars, essential pillars, are 5. زوج وزوجة وإيجاب وقبول وولي. 5 things. The husband and the wife, right? Because if you're missing one of those, there's no marriage. You can't marry yourself, even though people think they do it on Instagram now, but you cannot. It's not a valid marriage to us. وإيجاب. Ijab means an offer of marriage from the wife or the woman, or the wali of the woman, the guardian of the woman, to the husband. وقبول. Qabul means the acceptance of the offer of marriage from the husband. وولي, and the wali is the guardian of the bride. فشرط الزوج خلو من 4 ومن يحرم جمعها معها. So the shart, or the condition of the zawj, خلو من 4. What does that mean? That they should be free from 4. In other words, not have 4 wives already. So the maximum number of wives a husband can have is 4. So if he already has 4, he can't marry a 5th. So as long as there are 3 and less, then he can be a valid marriage partner. And maybe we'll get into about polygamy a little bit later, not right now. But just looking at the legality of it, he has to be married to less than 4 women already. وَمَنْ يَحْرُمْ جَمْعُهَا مَعَهَا. And also to not marry someone that can, 2 people who cannot be co-wives. So this would be 2 sisters, can't be co-wives. And the Maliki, I believe, also add an aunt and a niece, can't be co-wives. And definitely mother and daughter. And there's a different kind of setup for that, that we'll see later, that once one marries a daughter and consummates the marriage, he can never marry the mother after that. So that's kind of a given. But certainly 2 sisters, in other words, they share mother and father, or share mother, or they share a father, and also an aunt and a niece, and also what I just mentioned of mother and daughter with the tafsil, with the details that I think we'll mention later. So that's kind of the shart of the zawj, of the husband. And there are other things that are taken for granted that he doesn't mention. That would be like that the zawj has to be Muslim. So he has to be a Muslim. He has to have said the natqa bi shahadatain. You have to have said the shahadatain, even if he is not very practicing, but at the very least, he has to consider himself, and the community has to consider him to be a Muslim. And generally speaking, of sound intellect, of aql, because if he's not of sound intellect, then this is something that the marriage can be rejected on the basis of which. And also other conditions that will apply to both, such as him being able to consummate the marriage, being physically able to do that. That's also going to be something that someone who's not in that particular condition shouldn't get married also. And the wife has a right to reject him based upon that if it comes to light afterwards, and so forth. وَشَرْطُ الزَّوْجَةِ, and the condition of the bride, الْخُلُو مِنْ زَوْج, that obviously she's not married either, right? And a woman can only marry one. وَعِدَّةٍ مِنْ غَيْرِهِ, and to not be in her waiting period. أو استبراء. Istibra doesn't apply to us here. This is when for a bond maiden, but same concept as the idda. Or it could be istibra from illicit sexual intercourse. Let's say, لقدر الله, the girl was raped, then she should not get married until there's a istibra. In other words, monthly cycles pass by, so that or at least one, so that we are sure she's not pregnant. That's what istibra means. It means istibra al-raham. In other words, to find the innocence, as it were, literally speaking, of the uterus. In other words, that there's no fetus growing inside. And also the iddah. So the iddah would be for a woman who is divorced, which is 3 monthly cycles, or the iddah of a widow, which would be 4 months and 10 days. So they are not to get married, have a marriage contract within that period of time. And if they do so, it is considered to be invalid. It's not a marriage then, if it happens within the iddah or of the istibra. وَأَلَّا تَكُونَ كَمَجُوسِيَّةٍ وَلَا أَمَةً كِتَابِيَّةٍ وَتَجُوزُ الْحُرَّةُ الْكِتَابِيَّةُ بِكُرْهٍ. And also in terms of her religion, she shouldn't be Majusiya, a Magian, which is, in other words, it's not a Muslim, not from Ahl al-Kitab. وَلَا أَمَةً كِتَابِيَّةٍ, or a bond maiden who is from Ahl al-Kitab. وَتَجُوزُ الْحُرَّةُ الْكِتَابِيَّةُ بِكُرْهٍ. So a non-Muslim a woman who's Jewish or Christian, this is Ahl al-Kitab, bikur, but it's disliked to do so. And some of our fuqaha, they have said it's also on the condition that one is able to raise their children as Muslim. So if the husband, prospective husband, doesn't feel that's going to happen with the wife who's either Christian or a Jew, then it's not allowed then to marry such a person, and also to be able to live their own lives as Muslim and to practice their Islam freely, obviously. And traditionally this was happening. Muslim men were marrying kitabiyat when they themselves were living in Muslim lands, and so there was a hope that eventually that the kitabiyya, the Christian or Jewish bride, would eventually accept Islam. And many times that happened, and most often that happened. Nowadays, however, if one is living in a non-Muslim country and the Muslim husband is more or less living his life like everybody else, like a non-Muslim, then what kind of hope do we have then that they will be raised, the children will be raised in a Muslim household, and that the bride may eventually accept Islam? So this is a kind of a touchy, a little bit controversial issue. And I think especially in our time we have a lot of awanis, which are unmarried Muslim women getting into their early 30s, even 40s, and they're not married. And so there's kind of more of a communal aspect to this that has to be considered as well. فالله أعلم. وأما عدم المحرمية والإشكال وموجب التأبيد أو البت قبل زوج فشرط فيهما. So this is conditions that apply to both. عدم المحرمية, which means you can't be in a state of ihram. In other words, you can't be during Hajj or Umrah in your state of ihram. You cannot conduct a marriage or get married in that state, because that would be from the violations of the ihram. والإشكال, and ishkal I pointed out a little bit. Problematic things in terms of consummation or intimacy, or impotency or impotence, or even with the bride, if she's unable to engage in sexual intercourse for whatever physiological reason, things like that. This would be called al-ishkal. وموجب التأبيد. The Maliki have something unique to them, in that if one is to do a marriage while the woman is in her iddah, and then consummate that marriage, then the marriage is to be dissolved, and also they are never to marry again. This is called mujib al-ta'bid, something that would necessitate at-ta'bid, which would be that ta'bid means they never to marry. This also holds true for someone who has divorced his wife 3 times. So until she marries another and consummates a marriage with the other one, a new husband, and then they divorce her, she's widowed, she cannot remarry her first husband either. So that would also be something that applies to both of them. Mujib al-ta'bid aw al-bat, right? That would be the second category. That until they remarry, and then she remarries someone else, because it's not forever, but there's a condition, which is that she has to remarry and then be divorced or widowed for to return back to the first husband if 3 divorces have already taken place. فشرط فيهما. So those are البت قبل زوج فشرط فيهما. So this is a condition in both of them. Not mentioned in here, but mentioned by Imam al-Dardir also, is that there should be no conspiracy to hide the marriage. Al-ittifaq al-kitman. So generally you're going to have at least 3 other people involved, at least 3, when the marriage is happening. So you have the husband and you have the wife, then you have the wali, which is the guardian of the bride or the wife, and then you have 2 men who are the shahiday adl, who are the 2 upright witnesses. So if there is an agreement between the 5 of them that they're going to keep this thing secret and they're not going to tell anybody, then this nullifies, actually invalidates the marriage. So the Malikis were a little bit strict about this. So if they say we're going to keep it secret, no one's going to know, or the man's first wife is not going to know, and they keep it completely secret in this sense, then this would be an invalidation of the marriage contract. وأما عدم الإكراه والإحرام فشرط في الثلاثة. So عدم الإكراه, which means no one should be compelled or coerced to get married, والإحرام, as we said, to be in a state of ihram, فشرط في الثلاثة, is a condition for the 3. Which 3? The husband, the wife, and the wali, and the guardian. So you cannot be the guardian of someone if you're in a state of ihram either. كما أن إسلام الزوج والولي شرط في المسلمة. And as we mentioned earlier, that both the husband and the wali have to be Muslim for to marry a Muslim woman or to be a guardian for a Muslim woman. ومرض أحد الزوجين مانع من العقد فيفسخ إلا لصحة قبله. Or a chronic sickness, or let's say terminal sickness of one of the 2 that would prevent preventive of the marriage contract. فيفسخ إلا لصحة قبله. This marriage contract would also be dissolved by a judge if it was brought to his attention, except if at the time of the marriage contract there was no terminal illness and they were both healthy. But if there's a terminal illness while they're getting married, then this would be a mana of the aqd. And some might say, well, why would you do that if someone wants to get married in that state? Well, the problem is with the waratha, is with the heirs of one of the 2. And so the heirs have a right to the estate. And so there's a suspicion that a marriage like that would be unnecessarily advantageous for the one who's not sick, merely to get at the estate of the person who's sick. Allahu a'lam. That's how I read it. ولا يشترط في الولي عدالة ولا رشد إذا كان ذا رأي. So the wali, who is the father, generally speaking, or someone that the father appoints, or if the father is not around, someone else that can be appointed. He doesn't have to be necessarily upright or completely guided, as long as they have some sort of judgment. There will be conditions under which, when the sound judgment is not affirmed for the wali, right? If he's someone who says no to everybody, or he's not cooperating in marrying his daughter, or his wakil, his muwakkala, yani the one that he's been entrusted with to marry to someone who's good for her or appropriate for her, then in this case also the judge can get involved. والإجاب قول الولي أنكحت أو زوجت ولو لم يذكر صداقا أو وهبتك إن ذكر صداقا لا نحو أعرضتك. So we said the ijab, which is the offer of marriage, is very simple. Here in Arabic he would say أنكحت أو زوجت in the past tense. Or it could be in the present tense, with the understanding it means present right now, not in the future, not as a promise in the future. So أنكحت زوجت means I married you, both of them kind of the same thing. Ibnati, my daughter, or muwakkilati, or the one that I've been trusted to be her wali, to you. ولو لم يذكر صداقا, even if he doesn't specifically mention the sadaq or the dowry, but it's customary to mention the dowry at this point. Even if it's not mentioned specifically in terms of amount, it should at least be mentioned that there is a dowry to begin with. Or you could say الصداق المتفق بيننا or المهر المسمى بيننا, something like that. Or, upon the dowry that has been agreed to upon us is usually how it's done. أو وهبتك إن ذكر صداقا, or I give to you here, which is not لفظ صريح في النكاح, so it's not a literal wording of marriage, it's figurative, so then there has to be something else to ascertain that it's marriage. So if he says وهبتك, which means I gift you my daughter or my charge, in ذكر صداقا, if at the same time also the dowry is mentioned. So then when the dowry is mentioned, then there's no doubt that it's about marriage. لا نحو أعرضتك, which I don't know anyone would say that, but the fuqaha means someone actually did that. أعرضتك means I'll let you borrow let you borrow for a little bit. So something like that doesn't work. والقبول قول الزوج أو وكيله قبلت أو رضيت. And then the acceptance of the marriage offer contract or marriage offer from the husband or his agent, because the husband can also appoint his father or anybody to do that for him, and that's kind of like a traditional or customary honorary thing that they do sometimes. قبلت أو رضيت, I accept and I am contented, and usually we say both, قبلت ورضيت, right? I accept and I am contented with this. ويشترط للنكاح إشهاد عدلين قبل الدخول ويفسخ إن دخل قبله ويحدان إن حصل وطء ولم يفشوا بكوليمة أو دف. ويشترط للنكاح إشهاد عدلين, and also as a condition of validity, so not as a rukn, right, not as a pillar, because it could be done after, and this is where the Malikis diverge a little bit from the other schools of thought. As a condition of validity in nikah for the marriage, إشهاد عدلين, that two male witnesses who are upright, bear witness to the marriage قبل الدخول, before consummation. So it need not be right at the time of the marriage contract. Technically it could be the three of them. It could be the bride, the groom, and the guardian, and then the next day or 2 days later or however much later, but before consummation, they tell two witnesses in the same sitting, by the way, we got married and we want you to attest to our marriage that we got married. وَيُفْسَخُ إِن دَخَلَ قَبْلَهُ, right? And the marriage will be dissolved if they consummate before the attestation of the witnesses. وَيُحَدَّانِ إِن حَصَلَ وَطْءٌ وَلَمْ يَفْشُوا بِكَوَلِيمَةٍ أَوْ دُفٍ. And it's considered zina, actually fornication, if they did nothing to spread the word that they got married, like a marriage party, like a reception. And he says, oh, duf. Duf means the drum. They played the drum. In other words, that there was some sort of public announcement. So it doesn't mean the drum or the walima itself, but it means public announcement. So if you didn't have the two witnesses at the time, but you had the public announcement, it's still not right, but it's not considered to be zina. It's not considered to be just like lack of a non-marriage. And in some countries this used to be kind of a thing as zawaj al-urfi, right, which you could see here doesn't work, right? When it's just two university students and they agreed to get married and they said natazawaj urfiyan, right, kind of like I don't know how to translate that, just cultural or common marriage, and it's just the two of them and they wrote something on a piece of paper and there's no one else and nobody knows about it, so it's secret, and there's no witnesses, there's no wali, there's no guardian. It's not a marriage. And under the Sharia, it's not considered to be a marriage. So all of these things are in place to protect both the husband and the wife, to protect both parties, right? So that no one is taken unduly advantage of. Because marriage is, Allah describes it in the Quran as mithaqun ghalidh. It's a heavy contract, right? It's one of the heaviest contracts you can enter into. So it's not like a business transactional contract where you partner with somebody and then, if partnership doesn't work out, okay, fine, we'll just dissolve assets and liquidate and go on with our lives. It's much heavier than this because there's a strong community, emotional, psycho-spiritual aspect to it. It's not that easy. So it should not be entered into lightly, and it should not be exited lightly either, right? So all of these things are here to kind of give weightiness and seriousness to marriage when one enters it. And sexual relationships are not meant to be casual, and they're not meant to be just kind of spur of the moment. They're meant to be thought out because there are repercussions. Allah subhanahu wa ta'ala made it in a way that a child can come out of the sexual union. And so that's a whole nother life, and it's an amazing thing. But at the same time, it's a weighty thing, right? Not something to be taken lightly. وَصَدَاقٌ. So also for the validity of the marriage is something called the sadaq. Here the Malikiya call it sadaq or mahar, which means the dowry, a gift that is paid from the husband to the wife. أقله ربع دينار أو ثلاثة دراهم أو ما يقوم بأحدهما. So the least it could be is ربع dinar, which is a quarter worth of weight in gold, which in today's weights, maybe a few $100 or something, or less than that. أو ثلاثة دراهم, or 3 dirahim, which is weight in silver. أو ما يقوم بأحدهما, or that which is same thing in value as those two things. So today we have real estate or dollars or euros or sterling pounds, whatever it is. But one of the things I emphasize to people, it should be something, right? There shouldn't be like, no, we don't need a dowry, just forget about it, we're not going to have. No, you have a dowry, even if it's a little bit amount, but you name something because there has to be something that is named. And sometimes people say, well, the dowry will be that I'll teach her Surah Al-Baqarah or something like that. This is a little controversial because you could say, well, that's worth value in money in some terms of, someone might get paid to do that, but I don't recommend it. It should be something tangible, right? And also the Malikiya say that حلوله مندوب وتأخيره مكروه, which means to pay it all at the time of the marriage contract rather than having a deferred portion. And if you defer it without a specific date, it's not allowed in the Maliki school. So it has to be deferred if you're going to defer a portion of it to a specific date, not defer to whenever. لغير معلوم الأجل. Defer to a specific time. And the Malikiya don't like deferment to begin with, even though it has become customary in some cultures. So to have the full dowry and to be named and a specific amount is the best way to go. وَالْمُضِرُّ فِي هَذَا التَّوَاطُؤُ عَلَى إِسْقَاطِهِ, like we said. And what is harmful here, التواطؤ, that they all agree, like إسقاط al-mahar or sadaq, that we're not even going to consider it or pay it. No, this is a rukn, or it's a essential aspect of the marriage, the contract itself, and so it should be agreed upon. فلو سكت عن ذكر الصداق حتى حصل الدخول لزمه صداق المثل كما في التفويض وهو جائز والتسمية أولى. فلو سكت عن ذكر الصداق, so if they make no mention of the dowry for whatever reason, حتى حصل الدخول, until they actually consummate the marriage, لزمه صداق المثل, then the husband has to pay a customary dowry. صداق المثل, مثل means what's customary for someone who lives where they live and for who's in the same socio-economic situation as they are. This is called صداق المثل. So that's something that could be determined if there's a judge and you have access to that, or by a scholar who can determine, girls around here usually they get, $1,000 or 1,000 euros or 500 euros, or that's usually what they get as a dowry, and then that's what he has to pay. So either way, it has to be paid. كما في التفويض وهو جائز والتسمية أولى. Here I think في التفويض he means تفويض I'm not sure actually, I don't want to say what that is exactly, so let's skip that for now. But I think tafweed, yani tafweed, in other words, they make they mention there is a mahr, but how much it is, هذا الأمر مفوض إلى الزوج أو إلى الزوجة يعني. They decide at a later date. وهو جائز. والتسمية أولى. تسمية أولى. To actually mention specifically what it is better. And one of the comments here in the footnotes, which is important, is there is kind of a zahira, or like a phenomenon, that sometimes they'll mention a very small amount for the mahar and mu'ajjal, that's what's going to be paid right in time, and then you put a huge amount in the mu'akhar. A huge amount in the mu'akhar means something that is, multiple times as big. So they'll say $100 right now, and then the mu'ajjal, the mu'akhar, the deferred dowry will be like $10,000. And kind of the idea behind this is almost like an alimony. So it's so the husband will think twice about divorcing because they don't have to pay up. But the actuality is it's due either way. Whether they divorce or he dies, it's still going to come out of his inheritance, separate from her inheritance from him. And then the problem with that is, and we've actually heard cases like this, is since the husband realizes he has to pay so much and he doesn't want to pay it, then he may purposefully make the life of the wife miserable so that she will seek what's called al-khula. And khula means that she seeks the divorce. When she seeks a divorce, then he can request something in return. And usually that something in return is, I won't pay the deferred dowry. So he kind of makes her life miserable. She says, give me khula. He grants it. She's off on her way, and he gets out of paying the deferred dowry. And this is not with the objectives of marriage to begin with. This doesn't meet the objectives of the marriage. So it was not known in the early period of Islam that people made a deferred dowry. It's something that came later, and the Malikiya don't like it. So ويجب بيان نوع الصداق في التسمية وقدره وأجله. Like we said, the ajal. So if when they mention the sadaq, at least they should agree upon what it is, how much, and if there's going to be a deferred portion, even though it's disliked, when is it going to be due? And it can't be due at some date that is undetermined, like when we divorce or when I die. Say a month from now, 2 months from now, a year from now, whatever it is, it has to be something that is specific. وتملكه بالدخول أو الموت ونصفه بالطلاق. And she's entitled to it when they consummate, or when he dies. وَنِصْفُهُ بِالطَّلَاقِ. And also half if they divorce before consummation. She's entitled to half of it. If after consummation, then she's entitled to the entire thing. ويحل بالعقد الصحيح تمتع الزوج بما شاء من الزوجة إلا الوطأ بالدبر. So one line here about kind of the sexual etiquette. ويحل بالعقد, and it becomes permissible or legal, a legitimate, valid contract. تمتع الزوج بما شاء من الزوجة والزوجة من الزوج كذلك. Right? So they are free to enjoy one another except for anal intercourse. And generally speaking, anything outside of that is permissible. There are some ahadith that seem to indicate that looking at the private part of one's wife or one's husband may be disliked, but no one said it's haram. So even if that, and some of the fuqaha said it's permissible, that there's no issue with it. So even touching those areas and so forth is completely permissible. The only thing that is impermissible is intercourse via the anus. Allahu a'lam. وتحرم خطبة الراكنة لغير فاسق أو له من مثله. And it's haram. Here the khitbah means to try to engage a woman for marriage. Al-Rakina, the one who is already agreed or is engaged already. In other words, they didn't do the marriage contract, but they have kind of an agreement in place that they intend to get married. So tahrum هذه الخطبة, يعني to try to go and seek her out in marriage. لغير فاسق. except if the person is a fasiq. إما ظاهرا أو باطنا يعني إما ظاهرا في الأعمال أو في العقائد. So the fasiq here is someone who is a corrupt individual. And the way to look at this is sometimes women want to get married, and then someone comes and they agree to them, but they may not be an upright person. They could be fasiq. So if there's someone who is fasiq outwardly and is known to be that way, not spying on them, but they're known to be a user of illicit drugs, or a drunkard, or or they get high a lot, or they don't pray or anything like this, and the girl perhaps is settling for someone like that, then in this case one can try to see if there's still a possibility to get married to her, especially if you're not a fasiq, right? If you're trying to do your best and you really have your heart set on this girl and you feel like she's going to go the wrong way, then the Sharia here, the Malikiyya, telling you go give it a try, see what happens, and perhaps you save this girl from this corrupt person. Wallahu a'lam. والتصريح بالخطبة للمعتدة أو المستبرأة إن لم تكن مجبرة وإلا فلوليها. Also تصريح بالخطبة. In other words, to try to engage someone who's in their iddah or in their waiting period. This is also haram. What you can do, and they said in the books, is to التلويح دون التصريح. تلويح means kind of just give a hint, you sent her flowers, or something like that. Or you say, I think you'd make a good marriage partner. Or, some of them said to pronounce love, they said is talwih, not tasrih. I think that's tasrih, to be honest with you. That seems very overt, but they said, it has to be specifically saying, I come here to marry you. I want you to marry me. So if she's still in her iddah, hold your horses a little bit, wait for the waiting period to expire, and then I wish it was like that. Usually we have the opposite. Usually when women in our communities get divorced, it's like no one is interested in marrying them. So I wish there were people lining at the door who are waiting for the waiting period to expire to seek to marry them. فإن عقد فيها ووطئ أو تلذذ فيها أو وطئ بعدها مستندا لذلك العقد تأبد التحريم. And this is what we were talking about earlier. تأبيد التحريم. So if someone marries someone in the waiting period and consummates, or does the muqaddimat, so not full consummation, but there's some sexual act between them, or they do that contract within the waiting period and then they consummate after, مستندا لذلك العقد, to this invalid marriage contract that happened in the waiting period, تأبد التحريم, right? Then they will be haram to one another forever. And this was the method of Sayyidina Umar, and the Malikiyya followed him in that. The Shafi'is and the Hanafis don't have that, but the Maliki said تأبيد التحريم in that case. وندب خطبة عند التماس النكاح وعند العقد. And it is recommended to have a khutbah. In other words, just say a few words. عند التماس النكاح, right? When one is trying to get engaged. And عند العقد, and at the marriage contract. Usually this is the imam or the sheikh says it. But actually, as you notice here, there is no mention of an imam or a sheikh or someone to marry them. So literally, it can be just the husband, the wife, and the guardian. And then they're the ones saying the words. So the imam or the ma'dhoon or whatever he's called, he's there just to kind of make sure the process goes smoothly. But he's not an essential aspect of the marriage. He's just kind of like there to set the guidelines and make sure things are done properly, and so forth. وتفويض الولي العقد لصالح. Also, it's nudiba, yani it's recommended that the wali of the girl or the bride, يفوض الأمر, in other words, he deputizes or gives agency to someone who's a salih, someone they think is like an honorary thing at the time of the marriage, at the time of the contract. This sheikh or this, maybe the grandfather or an uncle or someone who's, it's like a customary honorary thing to do for them. وإعلان النكاح بكدف والله أعلم. And also to have i'lan, which is to have some sort of public statement, public reception, public celebration of the marriage, is also highly recommended to do. Wallahu ta'ala a'la wa a'lam. Alhamdulillah Rabbil Alameen. And we'll stop here until the next time. Assalamu alaikum wa barakatuh.